Are you ready? I'm going to open the doors. Okay, good morning and welcome to our Wednesday morning online seminar. Today we are joined by Richard Silver, Senior Partner of Silver Law, and he's going to be talking about Practical Completion, a game-changing case. As always, if you have any questions for Richard, please don't hesitate to use the chat or Q&A tool in the bottom panel, and he will answer as many of those at the end as he can. Alternatively, if there's something you do not wish to raise in an open forum, you are free to email him. You can see his email address there, richardsilver@silverllp.com. Okay, Richard, over to you.
Thank you very much, Julie. Good morning to you all. We're going to deal with the case of Mears versus Costplan Services. We actually were representative lawyers, solicitors for one of the parties, for effectively the landlord, who in this instance was seeking to argue that the works were practically complete. I will address this a bit later on and the ramifications from it. I suppose the starting point is to deal with what is or why parties seem to argue about practical completion. Those of you who have listened to my lectures in the past will know that my background is in construction. I worked on many projects, and regretfully, I must admit, none of them completed on time. And quite often, it was the case that we, as contractors, would enter into arguments with the employer as to whether the works were or were not complete. And equally, for that matter, we often ended up in arguments with subcontractors whether their works were complete or not, and what's more, whether the date for completion under the main contract was the date for completion under the subcontract, because quite often that results in many problems. Let's just say that you are a piling subcontractor. Your works will be complete very much earlier than the main contract, which means that the limitation periods and defect periods will not run concurrently. So quite often the contractors seek to amend the subcontract terms to make practical completion run concurrent with the main contract. But the effect of practical completion is a number of things. Number one is the limitation period under the contract runs from practical completion. The limitation period comes from the Limitation Act and is the date from which parties are permitted to take legal action. And when they are prevented or limited, runs from PC. So if you enter into a contract that is underhand, in other words, it is not sealed, not signed as a deed, the limitation period will be 6 years. So let's just go through that very simply. Nearly every contract we as individuals enter into on a daily basis will have a limitation period of 6 years. If you go and buy a new bathroom suite, you bought that, that's a contract. Any breach that flows from that, a party will have 6 years in which to take action. Now, you can increase that period to 12 years if you enter into the contract as a deed. It will normally be stated this contract is executed as a deed and will be signed by potentially 2 directors of the business or a director and a company secretary. Quite often you see the company seal being used or something of that nature. And in those circumstances, the limitation will be 12 years from practical completion. Now, I should just point out, you also have the Latent Defects Act. This applies to defects that cannot be seen, Latent Damages Act. It applies to defects that cannot be seen at the time, but can be seen sometime in the future. So when applying this to construction contracts, let's just say there was a problem in the ground, it was covered up, nobody knew about it. A party would have a right to take legal action within 3 years of knowing of this defect, of knowing it was sufficiently serious to warrant taking action, and knowing who was responsible. But they have a long stop of 15 years. So in other words, if they found 3 years after, immediately after PC this defect, they'd only have 3 years. But if they found out after 12 years, they would still have another 3 years. And this is going to be very relevant, the limitation period, particularly when we're thinking about things like cladding at the moment, where you've got cladding and the building was practically complete, let's say 12 years ago, and you are now concerned as the landlord that the cladding that's installed is not compliant or wasn't compliant, you need to be aware whether you can take legal action. And what generally happens where people are uncertain is they seek to sue everybody, from the contractors to the subcontractors to all the consultants. But you'll only be able to do so if the limitation period has not elapsed. And hence you can see how important it is to establish when PC occurred. Other factors that arise following PC is quite clearly the release of retention, or at least the first moiety. We then have under most contracts either a rectification period or a correction period, for example, under the NEC. We don't have to have those provisions. These provisions for a rectification period are for the benefit of the contractor. The reason is without these provisions, the contractor would not have a right to rectify. Very simply, the works would be deemed practically complete, and then any defects that arose post that date, the employer would rectify and then seek to recover those costs as damages from the contractor. By including a rectification period, correction period, we're thereby giving the contractor a right to go back and rectify. And as I'm sure you'll appreciate, more often than not, it will be far cheaper for the contractor to go back and rectify than the employer to do it at their own cost. Practical completion, quite often we have the works or as a section. So it may be that the works are broken into sections, and as a consequence, each section is certified as practically complete. Now, I just want to differentiate between sectional completion and partial possession. Now, again, JCT and NEC both provide for partial possession or handover. And what happens on partial possession is even though neither the works or the section are complete, or even the works that are taken into possession are complete, the contract provides they are to be deemed practically complete. Now, the difference between sectional completion and partial possession is sectional completion is something prescribed in the contract which has to happen when the works are complete. When that section is complete, the contract administrator must certify, and that's practical completion for those sections. But partial possession is where the parties agree post-contract that the employer wants to take into possession just an element of the works. It may even be the case that those works aren't totally complete, and the contractor is required to give their agreement subject to reasonable objection. But if they give their agreement, the works as taken into possession are again practically complete. Now that can be of major benefit because it will reduce, amongst other things, the liability to liquidated damages. So why is it so common that practical completion is disputed? Now, as I said, I'm a contractor. We always got involved in disputes on whether the works all were not practically complete. I act as representative for the parties, and I've acted both for employers, contractors, and for that matter, subcontractors, seeking to argue either the works were practically complete or were not practically complete. And I am a panel adjudicator, and again, quite often the matters before me are to determine whether the works were or were not practically complete. Now, it is my experience that quite often the employer doesn't want to take practical completion. It may be because they haven't let out the building as when it's going to be completed. And therefore, it's much better than taking on the insurances themselves that they withhold practical completion. Maybe that they haven't been to sell them. And again, that's another good reason why they don't want to take practical completion. And what I found is that in those situations, it is not uncommon for the employer to be issuing endless lists of snagging. And that's a question that's quite often put to me. Why or how many lists can an employer, a CA, an architect issue to the contractor for snagging list prior to practical completion? We as contractors all those years ago used to moan about there being 5, 6, 7 separate lists. And I'm afraid for you who are contractors listening, the answer is the employer can issue as many lists as they choose to, or as few as they choose to, because they're not obliged to snag at all. Put simply, the contractor has to complete those works, subject to what practical completion is determined to mean. And there is no obligation under the NEC or the JCT in the standard forms for the issue of any snagging lists. But the employer can issue them, and they are evidence of what works they think are incomplete and which is preventing practical completion. So the employer can issue as many lists as they like. And it's not uncommon, as I've said, for employers to try to issue as many as possible of these lists to try and prevent practical completion. I've had the opposite, however, where the employer, knowingly being aware that the contractor is entitled to a full extension of time, has actually certified the works as being practically complete before they were complete. The reason for that is to try and avoid having to issue an extension of time and thereby perceive that you wouldn't need to pay loss and expense. Now, I have been involved in a couple of adjudications where a contractor's alleged practical completion did not occur. But let me just point out, extensions of time and loss and expense under the JCT are separate. You can still claim loss and expense for, in theory, works that are undertaken post-practical completion if you can show that they represent a relevant matter and the costs that you've incurred as a result are because of that relevant matter. Extensions of time are simply to deal with the mechanism of time and liquidated damages. Without those provisions, time can be rendered at large. But the loss and expense provisions under JCT are separate. You will not find them in the same section of the contract. They are completely separate. So when I'm working for a contractor and we're awarded an extension of time for force majeure or exceptionally adverse weather conditions, I will simply respond and confirm receipt and thank the employer for that award, but point out that I don't agree that that was the relevant event. But in any event, we will be claiming it as a relevant matter for which we will be seeking loss and expense. Now, so far as contractors are concerned, more often than not, they want practical completion to be certified as soon as possible, because as soon as practical completion is certified, the damages come to an end. So you will no longer be liable to liquidated damages, which most contracts, main contracts, provide for. So the contractor is very, very keen to get practical completion certified. Now, quite often when I'm involved in disputes with contractors, they say to me, you know, we need an extension of time to such and such a date. And the first thing I look at and say, is that correct? Or is it the case that maybe practical completion occurred much earlier? And one of the main circumstances where it can be seen that practical completion has been achieved much earlier, where there has been a fit-out contractor going into the building much earlier than PC, working on behalf of the employer, or where the employer has simply taken possession of the works, particularly where a contractor is building a house for an employer and the employer moves in. So simply the fact that the certificate for practical completion is issued on a date doesn't necessarily mean that is the actual date when practical completion occurred. So let's go through the cases dealing with practical completion. Now, we have various terms. In JCT, we have the term practical completion. In NEC, we have completion. ICE, we used to have substantial completion. Why can't we just make it easy? Why can't we just simply say completion? And if we look at this case back in 1898, Sumpter versus Hedges, that's what the court said. It's completion. You don't get paid until it's complete. It's not complete. So it means everything. That surely must be an easy way of dealing with it. I know contractors will be a little bit concerned, but for you as employers, surely that's the easiest solution, is it not? Well, the problem with that is that if you've got a contract with liquidated damages for, say, £10,000 per week or part thereof, and you are refusing to certify practical completion because there is one screw missing from the hinge on a door, you are seeking to impose a penalty clause. You are seeking to impose upon the contractor a liability for £10,000 for failing to put a screw in a hinge. It's not reflected. And as a result, that clause will fail. So what we've got to identify is that practical completion or completion has to be something slightly less. It is still complete, even though there's no screw. But in the case initially that we're dealing with in Sumpter versus Hedges, it says everything must complete. But then we had a change in Jarvis and Sons versus Westminster Court. And what was basically said was that the works must be, for all intent and purposes, complete to allow the employer to use them as intended. And this is called the restrictive test. It isn't quite as onerous as everything being complete, but it is fairly close. It's going to require or allow the employer to use and take possession of the works and to use them as he intended. Now, I just add, as he intended and detailed in the contract. If you cannot determine how they were intended to be used, then that is going to be a difficult thing to the employer to prove. But the case of Jarvis said that we had a restrictive test, and it was that you had to be able to complete all the works and they could be used by the employer. But that was changed in 1981 with Neville versus William Press, and an alternative test was put forward called the flexible test. And it used the term that I often use in my seminars of trifling, that the works have to be complete, save for items that are de minimis or other referred to as trifling. Now, unfortunately, the term trifling and de minimis are not defined. And the reason for that is what is trifling or de minimis will depend upon the particular project and the particular defect. If you're working in a hospital and you're having building works in a hospital, I would suggest to you that what will be trifling will be very different to if you're building a shed. And that's the problem is in determining whether a defect is sufficient to prevent practical completion, one must look at the works and at the defect. It is very difficult to simply define it at the outset in the contract. But the case in Neville versus William Press was that the works were complete, save for items that were de minimis or trifling. You will then see that view was backed up in Mariner versus Atlas in 2007, and again a reference to trifling. I'm also going to take you back to this case in 1995. I remember when this came out, I was at university at the time, and it all pertained to a swimming pool. And what had happened is a employer had appointed a contractor to build a swimming pool, and he very much liked his swimming pool. But the problem was it wasn't quite as deep as it should have been. The swimming pool was 6 foot deep, but it should have been 7 foot 6 inches deep. It was also slightly shorter than it should have been. Now, the employer had no intention whatsoever of digging up this swimming pool. But what he wanted to do was to seek to recover his loss. And he said, well, it's a very simple thing to calculate. Let's just say that the contractor was paid £10,000 to build the swimming pool. What the employer said was, I should charge you the cost of repair. And in order to repair it, what we've got to do is to dig up the whole of the swimming pool and put a new swimming pool in. And the cost of that will be £11,000. So we've got £10,000 to build the swimming pool. and then £11,000 to repair it. So, Mr. Contractor, please pay me £1,000 for the pleasure of having me a new swimming pool in the garden. And that's what the employer, Mr. Forsyth, effectively sought. He sought not to pay for the swimming pool at all, but to actually paid £1,000 extra for having it installed. So he effectively came out with a free swimming pool. And it was all turning on, in part, whether the swimming pool could be deemed as practically complete, notwithstanding that it wasn't built to size. And what the court said was it was practically complete, and it was disproportionate to force the contractor to rectify it in these circumstances because the employer was happy with it. So let's just make this really, really clear. We have a swimming pool that's 7'6", is 6 foot deep, but should be 7'6" deep. So it is quite a bit shallower. But the court said that the cost of rectifying it was so extreme, it was unnecessary. Now, it did rely upon the evidence of Mr. Forsyth and the fact that in effect, he wasn't looking to replace it. But it has had ramifications on many jobs. How often are there defects in the works where the employer says they are willing to complete it? And if they so do, and the JCT and the NEC both provide for it, if they do, the cost is not the cost of rectification. It is the cost incurred by the employer. Now, in this situation, the damages awarded to Mr. Forsyth were nominal. They were not very high, and they definitely weren't the costs of the swimming pool. He got very little and was required to pay for the swimming pool. And you can again see that practical completion doesn't mean the works are complete. They must be complete, save for items that are de minimis. And in this situation, they considered the lack of depth of the swimming pool to be de minimis or trifling. It was not significant, and the costs of rectification, most importantly, were disproportionate to the benefit that would obtain. I'm now going to turn to the textbooks. Quite often when one's in legal dispute, people refer to the relevant textbooks. This is construction law. And again, you will see that the works must be complete and able to be used for their intended use, save for the defects that are de minimis or trifling. Keating, I'm sure you've all heard of Keating, again refers to the term de minimis, saying that the works must be free from patent defects, save for items that are de minimis. And just dealing with patent and latent defects, patent defects is a defect that is known at the time of practical completion. Defects that are not known at the date of practical completion but become noticeable post-PC are latent defects. And in Keating, when determining practical completion, it's saying that the works must be complete, save for items that are de minimis or trifling. Which now takes us to this game-changing case, Mears versus Costplan. And the facts of the case are that Mears was a tenant, or a proposed tenant, who were going to take a 21-year lease for the buildings, which comprise 2 blocks of student accommodation in Plymouth. And the annual rent was not an insignificant figure of 1.67 million. So, provided the works were certified as practically complete, they had to take the lease and thereby pay 1.67 million a year. And as you can imagine, if they could avoid practical completion having been achieved, they could avoid paying the 1.67 million. So that's what they were looking to do. They did not want practical completion certified, because if it was not certified, they did not need to take up the lease. We've got the key clauses here. clause 13.72, it provided that if practical completion was not certified by the 18th of September 2018, referred to as the long stop date, either Mears or the landlord could give notice of termination, and thereby there was no need for the lease to be given. So it was both the landlord or the tenant could terminate the requirement to enter into the lease. So far as whether practical completion had been certified, that was at the sole professional discretion of Costplan, who was the employer's agent. In other words, they were no different as the contract administrator or architect under the contract. So it was at their discretion as to whether or not the works had or had not achieved PC. And where was the problem? Well, the problem was all to do with clause 6.2.1, which required all the rooms of the two blocks of the buildings not to be reduced by a percentage of greater than 3%. So we had a whole set of drawings, and they all showed the dimensions of the relevant rooms, and what was required, that none of them must be reduced by a greater than a 3%. Now, Mears, in seeking to avoid practical completion, alleged, and which proved to be the case, that a number of the flats were in fact less than 3% smaller than specified. But other rooms, including a bin saw, was less than 3%. And what Mears did was, first of all, to obtain an injunction, which they were successful in obtaining, in restraining Costplan from issuing PC until it was decided at trial whether the works had indeed achieved practical completion. And of course, in those proceedings, Mears' arguments, the works could not be practically complete because there was a defect in those works, and that defect could not be considered as trifling or de minimis. And that defect was that the room sizes were more than 3% smaller than shown on the drawings, and the contract expressly provided that they must not be less than 3%. So there was quite clearly a breach, quite clearly a defect, and upon such basis, Mears argued the works were not practically complete, and therefore they could not or were not obliged to enter into the lease and could terminate. The court, in first instance, decided that indeed there were 56 rooms of the building that were smaller than 3%, and they accepted that it was in breach of what the contract required, but they decided that that would not prevent PC. And the reason was they said it was commercially absurd for that to be determined as a defect. And they gave the example of the bin store. The fact that the bin store was less than 3% smaller than specified could not be seen as anything more than a trifling problem. It couldn't be seen anything more than being de minimis. And therefore, to argue that practical completion should not be certified simply because the rooms were slightly smaller was wrong. And therefore, the date of PC was determined as the 18th of September 2018, and Mears were thereby obliged to enter into the lease, which obviously they did not want. So Mears went off to the Court of Appeal and said, we do not accept that judgment, we want it to be considered. And as far as they were concerned, the fact that these rooms were less than the 3% stated on the contract drawings was material and substantial breach. The answer is if they were successful, they were able to terminate the agreement, PC would not have been certified correctly, and they could get out of the lease. However, the Court of Appeal said that was wrong. They again went back to the flexible test, and they determined that based upon the facts, the simple fact that the rooms were less than 3% was not sufficient for that defect to be seen as anything but de minimis or trifling. And they said that if it was to be held otherwise, it would go against the case of ruts in the swimming pool that I mentioned before. What this case identifies is that it is very difficult to establish what actually is practical completion. What we know is that the term that it is free from defects other than items that can be seen as trifling or de minimis continues to be the current precedent. But it will depend upon what is stated in the contract, what are the nature of the works, and also what is the alleged defect. And we'll all deal with a question of fact and degree and the ability for the employer to use the building for its intended purpose. In our situation in Mears, the fact that these rooms were less than 3% did not affect the employer in its intended use of the building. There was nothing to prevent it being used. On the facts, in Ruxley, the swimming pool did not prevent the employer from using this swimming pool. It was not an Olympic swimming pool. And I think this is an important point. If that swimming pool had been built for, let's say, a local authority for the future Olympics, then it would not have been a de minimis defect. The employer could have required it to be of an Olympic size because otherwise it cannot be used. But because this was for a person in their back garden, the lack of depth was not seen to be sufficient to warrant practical completion being withheld. And equally, it was also seen that it was disproportionate to require the contractor to rectify. So we can see it's going to depend upon the use that the building is going to be put for. And for a swimming pool, it's going to be different where it is for an employer who's going to be using it for their own personal use to an employer who's going to use it, for example, in the Olympic Games. Another fact is whether you can actually repair the defect or whether it is economically to do so is irrelevant. Going back to the case in Mears, how could you have changed all those rooms by 3%? I mean, the reality is you're not far short of knocking the whole building down. They said that was all irrelevant. It was just a matter of the facts. And on the facts, it was the case that the 3%, slightly more, was no big deal. And we do need to remember, 3% would have been okay. The 3.1% was non-compliant. You can see it could be very, very minor. Yet this was the reason that was being argued for practical completion not having been achieved. So what are the implications of this judgment? Well, number one is that we've identified that PC is it is not as easy to define or establish as one would like. You can, in the contract, stipulate what is required to achieve PC, but you need to be clear as to whether those requirements prevent PC. In the case of Mears, it didn't say it prevented PC. All it said was this was what was required to be done. The situation may have been different had the contract provided that PC would only be certified on the proviso that all the rooms were not less than 3% smaller than what was shown on the drawings. That's not what the contract provided. He only provided that the rooms must not be greater than 3% smaller. It didn't go on to say, and if this is not achieved, PC shall not be certified. So you can agree within your contract specific requirements that need to be met in order for practical completion to be certified. And for those of you who work on NEC will know that's the case because NEC is different to JCT. NEC actually includes a provision that enables an employer to put down particular preconditions to completion, and which could include, for example, that all the rooms shall not be 3% smaller than shown in the drawings. As far as the certifier is concerned under the project, whether the cost of repair is extremely high or very minimal is irrelevant. They should focus purely on the fact and the degree. Now, I do recognise that quite often the certifier doesn't necessarily do that, particularly when they are, let's just say, trying to be more helpful to their employer. So if you are faced with a job where, for whatever reason, you feel that practical completion is wrongfully being withheld, and you're being issued with large amounts of lists that which in your view are de minimis or trifling and ought not to prevent practical completion, what I would strongly suggest that you do is to take photos and videos of the works as they are at the date you certify, you argue that practical completion has been achieved, and then instruct another architect to give his view as an expert. Because simply the architect under the project may not be the right person to determine. He may have determined wrongfully that the works are not practically complete, or wrongfully that they are practically complete, depending upon the circumstances. Under the JCT and NEC and most other standard forms of building contract, the adjudication provisions, arbitration, litigation do allow the opening up of any certificate, and which would include a certificate of practical completion. So, advice for new projects. I do think that all standard forms are not appropriate without amendment. You know, no one, JCT, NEC, has drafted this contract for you, be it you as a contractor, subcontractor, or employer. They do not reflect exactly the nature of the works. Now, the NEC indeed recognises this. The NEC has its option Z, where you're allowed to include further amendments to the contract. It's my view that under the JCT forms, you should also seek amendment. And one of the amendments you should be considering is the issue of practical completion. My own view is that I would be saying that the contractor is obliged to issue a snagging list prior to practical completion. I would also include amendments for the review of those snaggings, the de-snagging and everything else as part of the process. I would also include bespoke provisions for the rectification of defects within set periods, say for urgent ones 24 hours, less urgent 7 days and less urgent 14 days. But the other thing I will be doing is putting in some more information on what is deemed to be practical completion. In other words, what has to occur in order for practical completion to be certified. Now, for example, under the JCT, you've got to provide your health and safety file and all the paperwork for the CDM regs. And until that's achieved, PC cannot be certified. But you can expand upon that to include other provisions. More often than not, unfortunately, this is not considered. So, in summary, practical completion, substantial completion, what is it? It is complete, save for items that are trifling. As to what is trifling or de minimis, it will depend upon the facts. The building must be able to be used for its intended use, and whether the item is de minimis or trifling will depend upon the contract and also how the building is going to be used. And we go back to our swimming pool. The fact that the swimming pool is nowhere near as deep as it should be may or may not be trifling. In the case of Mears, the fact that the rooms were slightly smaller than they should be and could not be rectified did not prevent practical completion. Julie, any questions?
Oh, sorry. We don't appear to have any yet. No, none pre-submitted. So if anyone has got any questions to Richard, please type your question up now. Thank you very much, Richard. That was, as always, an interesting talk on practical completion. That is the end of our seminar schedule for the first part of this year. We're back again in September. We don't run in August, obviously, because most people are on holiday or a version of it in these pandemic times. but we kick off again on the 1st of September with recovery of loss expense and global claims in the morning. And with Richard, and John is presenting legal costs in construction litigation, adjudication and mediation in the evening. So if you'd like places on either of those, drop me an email, seminars@silverllp.com. As we said earlier, Richard's email address there, richardsilver@silverllp.com. If you have anything specific you wanted to ask him, please feel free to email him directly. He will happily answer your questions. So thank you very much, everyone. Have a great day. Richard, I'll speak to you later. Thank you very much for your time, as always.